Namaste and welcome to Daily News Simplified, the what, why, and how of newspaper reading. Now, we would be analyzing the Delhi edition of the Hindu newspaper of 14th of December 2018, and the news that would be covered today is given on the screen, and the timestamp for the same is given in the description and the comment section given below. And so, now with this, let us start with the first article. Now, we have taken this lead editorial from the editorial page on page 8. Now, what this article starts by referencing is a particular judgment that has been given by a judge of the Meghalaya High Court. However, it is not required for us to understand as to what is the controversy with regards to this judgment. Now, what this article provides are three aspects. Now, the first aspect that the author provides are two causes of concerns with regards to judiciary in India. The first cause of concern is the evolution of judiciary in India as being executive courts. And the second cause of concern is the evolution of judiciary in India as being administrative courts. Now, after that, the second aspect that the author provides in this article are various aspects of judicial independence. And after that, the last aspect that we need to understand from this article is how the author has talked about judicial accountability. Now, this article and the upcoming explanation with regards to these 3 points. Now, this article and the upcoming explanation on these three aspects should be seen from the perspective of GS Paper 2, within the section Governance, Constitution and Polity, and within the subsection Structure, Organization and Functioning of the Executive and Judiciary, and secondly from the perspective of the subsection Separation of Power between various organs. So now let us first understand as to what have been the causes of concern with regards to the formation of an executive court and an administrative court that the author has highlighted with regards to the Indian judiciary. Now, one of the two concerns that has been raised by the author is the evolution of an executive court, and the second is the evolution of an administrative court. Now, let us understand as to what the author means by the evolution of an executive court. Now, according to the author, an executive court has its moral and political judgments in alignment with the government of the day. Now, those courts whose moral and political judgment is in alignment with the view of the government are also known as committed judiciary, and is generally found in authoritarian states such as Saudi Arabia, Pakistan, Afghanistan, China, and other authoritarian state countries, wherein what generally happens is that the judges in those countries generally provide those judgments which are morally and politically acceptable to the authoritarian government. The second point of the author with regards to evolution of an executive court is that the court is used to promote the agenda of the government. When what the author means by this is that a particular government may have some moral or political view, and this government then uses the judiciary to promote that particular moral or political agenda. The third point highlighted by the author with regards to evolution of an executive court is that the court avoid checking and limiting the misuse of the power of the government. Now, this again is seen in authoritarian states. Now, an example of this is the judiciary of Myanmar. Now, as you already might be aware of, there are a large number of Rohingya refugees which have been persecuted by the government of Myanmar. However, there has been a lack of intervention by the judiciary of Myanmar in limiting the misuse of the power of the government. And the fourth and the last point highlighted by the author is that the evolution of an executive court leads to instances of political posturing by judicial officers. And it is with regards to the fourth point that the author has highlighted a concern with regards to India, wherein the recent example of the judgment of the judge of the Meghalaya High Court showcases pro-government political posturing by judicial officers. And according to the author, this form of pro-government political posturing by judicial officers should be tamed within India. So now hopefully you have understood the viewpoint of the author with regards to the evolution of an executive court. Now let us understand as to what is the author's view with regards to evolution of an administrative court. Now, by an administrative court, the author means that a court which directs a host of administrative activities to the executive government. Now, the functioning of administrative activities is within the purview of the executive government. But however, what the author is trying to highlight is that the judiciary in India is evolving into an administrative court, whereby they are directing a host of administrative activities which is under the purview of the executive government, in which the author has given the example of the National Registry and of various other cases in which the courts in India have directed a host of administrative activities to the executive government in India. And according to the author, the courts have been directing these host of administrative activities under the purview of judicial activism. And it is within this regard that the author has raised a concern that these administrative activities which are being directed by the court are beyond the accountability of citizens of India. When what the author is trying to highlight is that the various administrative activities which is undertaken by the executive government, the citizens can hold them accountable at every election. However, the administrative activities which are being directed by the courts are beyond the accountability of citizens of India. And therefore, it is with regards to this that the author has raised two concerns. The first being the evolution of the Indian judiciary as being an executive court, and second, the evolution of the Indian judiciary as being an administrative court. But however, you have to understand that all of these points, especially the points that have been given with regards to the evolution of the executive court, are personal opinions of the author. And therefore, when using these points for writing an answer in the mains examination, you should be careful in not showcasing as being overcritical of the Indian judiciary, whereby there have been recent instances of political posturing by judicial officers, whereby they have taken a moral and political judgment which was seen in alignment with the view of the government. However, there have been very few instances of this happening, and based on those instances, it cannot be said that the Indian judiciary is evolving into an executive court. However, with regards to the evolution of an administrative court in the Indian judiciary, there have been a number of instances in which the judiciary of India has directed the executive government for various administrative activities, such as the National Registry of Citizens, among other. And thereby questions on judicial activism have been asked in the UPSC mains examination. Now after this, let us understand the second aspect on which the author has focused upon, which is judicial independence. Wherein according to the author, there are two forms of judicial independence that is required. First is the independence of the judiciary from the executive government, whereby it means that the judiciary of any country should not evolve into an executive court, whereby they should have independence from the executive government and apply the required checking and limiting of misuse of power by the executive government. And the second point with regards to judicial independence that the author talks about is the impartiality of judicial officers. When according to the author, judicial officers must perform their constitutional role independent of personal biases, political and moral beliefs, and political ideologies. And therefore, according to the author, the independence from the executive government and the impartiality of judicial officers are both required to ensure that there is independence of the judiciary. The author also highlights on how the Indian judiciary has been ensured that it is independent from the executive government, whereby judges are ensured fixed salaries, security of tenure, and apart from this, the author has also highlighted that the judiciary has also ensured that there is limited role of the executive government in the appointment of judges. However, it is within this regard that even though there have been various provisions to ensure that the judiciary is independent from the government, similar provisions or measures, according to the author, are lacking with regards to ensuring the impartiality of judicial officers. And therefore, it is on account of this that the author moves to its third aspect in the article, which is judicial accountability. Now, the first mean of judicial accountability that has been given by the author is to ensure that judges follow the primary compliance to the constitution, text of legal instrument, and the procedure of judicial precedent. And apart from this, what the author is recommending is to form a legal culture in the form of unwritten and established norm that must be created and maintained by judges, lawyers, legal academics, the press, and the citizens of India. And so therefore you've also understood as to when the author says that to maintain judicial independence, there should also be impartiality of judicial officers. However, according to the author, the Indian judiciary currently lacks measures to ensure that there is impartiality of judicial officers. And it is within that respect that the author has given 2 points with regards to holding judicial accountability. The first measure highlighted by the author is that judges should maintain primary compliance, first to the Constitution of India, second to the text of legal instruments such as various laws that have been formed, and lastly to the judicial precedent, which in simple terms means that judges follow the decisions that have already been made by an higher court. And the second measure which has been highlighted by the author is to form a legal culture within India, which would include various norms which has been established and maintained by judges, lawyers, the press, and the citizens of India, so as to ensure that there is impartiality of judicial officers, and if any judicial officers engages in political posturing, they can be held accountable through these norms which has formed as a part of India's legal culture. So now hopefully you've understood the three aspects which have been highlighted by the author in this article. Now our main question for your practice is what measures have been provided to ensure the independence and impartiality of judicial officers, whereby you can answer this question with the help of the article and the explanation given in this section. And so now with this, let us move on to the next article. Now we have taken this article from page 7. Now what this article talks about is that the Supreme Court has said that the aged population of India currently lack basic rights, which is a growing cause of concern. Now the cause of concern that has been raised by the Supreme Court is that the Government of India, in the name of economic budgeting and denying welfare protection to the senior citizens. And according to the Supreme Court, it violates Article 21, which is the fundamental right to life, to live with dignity, health and shelter. Apart from this, the Directive Principle of State Policy or the DPSP under Article 41 states that the Government of India should make effective provisions for public assistance in cases of old age. And therefore it is within this regard that the Supreme Court has asked the central government that it is a statutory right of every aged person to receive welfare under the Maintenance and Welfare of Parents and Senior Citizens Act of 2007. And apart from that, the Supreme Court has also asked the central government to obtain the necessary information from all state governments and union territories about the number of old age homes in each district, and also include the details from states about the medical facilities that are available to senior citizens in each district. However, you have to understand that this last point about the collection of information is a news in transition, when we will have to wait and see on how the central government provides the status information to the Supreme Court. But hopefully you have understood that the Supreme Court has raised a cause of concern with regards to the rights of aged population, wherein the Supreme Court has observed that the government is denying welfare protection to senior citizens due to economic budgeting, wherein according to the Supreme Court, this violates the right to dignity, health and shelter of senior citizens under Article 21, which is right to life. And apart from that, under Article 41 of the DPSP or the Directive Principle of State Policy, the government should make effective provisions for public assistance in case of old age. And it is within that regard that the Supreme Court has said that the central government should effectively implement the Maintenance and Welfare of Parents and Senior Citizens Act of 2007 and also collect information from states and union territories about old age homes and medical facilities available for senior citizens in every district. Now with regards to your UPSC syllabus, this article will be placed in GS paper 2 within the section Social Justice and within the subsection Laws Constituted for the Protection and Betterment of Vulnerable Sections. And by vulnerable section, it means senior citizens. Now a question for your practice is the Directive Principle of State Policy mention which of the following vulnerabilities for state assistance? Now what you need to do is pause this video, solve this question and wait for 5 seconds for the correct answer. Now the correct answer to this question is D, 1, 2, 3 and 4, wherein under Article 41, which is a part of the Directive Principle of State Policy, old age, unemployment, sickness and disablement are all vulnerabilities that require state assistance. And so now with this, let us move on to the next article. Now we have taken this article from page 7. Now what this article talks about is that the Central Groundwater Authority has decided to levy a water conservation fee. And this fee would be levied on groundwater that is extracted by industries and some sections of domestic users. Now you should see this article and the upcoming explanation from the perspective of GS paper 3 within the section Environment and within the subsection Conservation and Environmental Impact Assessment. And with regards to your prelims examination, the water conservation fee should also be seen with regards to general issues on environment. And you should also see this news from the perspective of public policy. And so now let us understand this article. Now the Central Groundwater Authority is under the Ministry of Water Resources, whereby it has introduced the concept of a water conservation fee. And this water conservation fee would be levied across India from June 2019. Now on a separate note, what you should also understand is that the Central Groundwater Authority, which was constituted under the Environment Protection Act of 1986, and it has the mandate of regulating groundwater development and management in the country, and is currently working under the Ministry of Water Resources. And the reason why we're telling you this is because various regulatory bodies, statutory bodies and constitutional bodies are mentioned in the Hindu newspaper. and it is important to understand the basic features about them, since they're continuously asked either in the prelims or the mains examination. Now, the water conservation fee would vary with the category of the area, the type of industry, and the quantum of groundwater extraction. And these are the three main criteria of the water conservation fee. And it is within that context that the water conservation fee is designed to be progressively increasing when we move from a safe to an overexploited area, or when we move from a low to high water consuming industries, and when we move from a low to a high degree of usage of groundwater extraction. So it means that if the fee in a safe area is rupees 10, but in an overexploited area the fee might be rupees 50, and similarly in low water consuming industries the fee might be rupees 50, but in high water consuming industries the fee might be 80. And it is within that context that the groundwater fee would be progressively increased based on these three criterias. Now, the main significance of the water conservation fee is first, the high rates of the water conservation fee is expected to discourage of setting up of new industries in areas which have overexploitation of groundwater resources. And secondly, it is expected that the water conservation fee would act as a deterrent or lead to fears among industries for large groundwater extraction. And apart from this, the third significance of the water conservation fee is that it would compel industries to adopt measures to efficiently use water. Now, these are the three main significance of the water conservation fee. However, you have to understand that the water conservation fee is yet to be implemented in India and would be introduced across India from June 2019. And therefore, this is something that we have to look forward to. Now, another criteria of the water conservation fee is that there are various industries which are exempted from the water conservation fee. The first is the agriculture sector, which is also the largest consumer of groundwater. Apart from that, the second exempted industry would be defense establishment. The third exemption would be for individual households which are using a less than 1-inch diameter delivery pipe. And the fourth exemption is for users who don't use electricity to extract water, such as individuals who use rope pulley wells and certain users who use spring waters in Himalayan ranges. However, again you have to understand that this water conservation fee has not yet been implemented, and whether this criteria remain the same is yet to be seen. But hopefully you've understood as to what is water conservation fee and what is Central Groundwater Authority. Now, question for your practice is which of the following statements on Central Groundwater Authority are correct? And what you need to do is pause this video, solve this question, and wait for 5 seconds for the correct answer. Now, the correct answer to this question is A, one only. Wherein, with regards to the second statement, the Central Groundwater Authority is under the Ministry of Water Resources. And so now with this, let us move on to the next article. Now, we have taken this article from page 9. Now, what this article talks about is the death penalty, wherein three viewpoints have been provided. The first viewpoint highlights that yes, the death penalty should be abolished. The second viewpoint highlights that the death penalty should not be abolished. And the last viewpoint has taken a middle path. Now we'll try to understand this article in two aspects. First, with regards to the point in favor of death penalty, and second, with regards to points against the death penalty. Now, with regards to your UPSC syllabus, the points in favor and against the death penalty should be seen from the perspective of JS Paper 2, from the section of governance, constitution, polity, and social justice. So now let us first understand as to what are the points in favor of the death penalty. Now, the first point in favor of death penalty is that the Law Commission in its 35th report has called for the retention of death penalty. And the reason the 35th Law Commission report has called for the retention of death penalty, since death penalty acts as a deterrence. The second point in favor of death penalty is that the 262 Law Commission report also reviewed the death penalty, and this commission report did not suggest to abolish the death penalty. The third point in its favor is that the Supreme Court, in its various observations, has said that the capital punishment helps in defending law and order. The fourth point in its favor is that unlike the European countries, India does not have a peaceful neighborhood, and therefore terrorists, extremists, and Maoists are required to be punished through the death penalty. And it is within that context that the fifth point is raised, wherein India should not be compared to European countries, since India does not have a peaceful neighborhood. The sixth point in the favor of death penalty is that the demand for death penalty is currently a reflection of the demand from the Indian society. Wherein if you take into account the recent Nirbhaya case, wherein during the protest for the Nirbhaya case and for other cases of rape, various sections of the Indian society have showcased that they want the death penalty for rapists. And therefore a point in favor of death penalty is that it reflects the demand from the Indian society. The seventh point in the favor of death penalty is that it comes out of the judicial process. And the Supreme Court in the Bachchan Singh case has said that the death penalty is constitutional. Now these are the seven main points which are given in favor of the death penalty, whereby most of these points reflect actual facts, such as the point from the Law Commission reports and the judgment of the Supreme Court. And the rest of the points, such as with regards to Indian society, derive from a conceptual support for death penalty. And so with this, let us understand the points which are against the death penalty. The first point against the death penalty is that it is arbitrary and depends on the decision-making process of one particular person, wherein it has been said that the death penalty is given based on the decision-making process of a particular judge, and it has been seen that those judges who favor the death penalty give the death penalty in their judgment, and judges who do not support the death penalty do not provide the death penalty in their judgment. And therefore the author has raised a concern that the decision-making process of a death penalty is arbitrary. The second point against the death penalty is that it is error-ridden, wherein the Supreme Court in itself has said that in the past 1.5 decades, about 25% of the cases in death penalty have been wrongly given. The third point highlighted by the author is that death penalty has not shown any form of deterrence against crime. Now it has been said that by giving the death penalty for a particular crime, people would be more fearful in the future in committing that crime. However, evidence has shown that the death penalty has no form of deterrence against crime. The fourth point highlighted against the death penalty is that almost 142 nations in the world have banned capital punishment or the death penalty. The fifth point which is given against the death penalty is that it is mostly given to poor people who do not have proper access or do not have proper capability to hire a lawyer to provide a strong case for them. Now these are the 5 main points which have been provided in the article as being reasons for not providing the death penalty. Now based on this article and the explanation given in this section, a question for your practice for mains examination is examine the pros and cons of capital punishment. What is the contemporary scenario in application of death penalty in India? Where you would be able to answer this question with the help of the article and the explanation given in this section. And so now with this, let us move on to the next article. Now if you take a look at the description section of any Daily News Simplified video, what you'll find is a special section called Daily News Headline or DNH. And under DNH, what you'll find are the various news articles from the Hindu newspaper which are required to be understood for your prelims and mains examination. And each article of the Hindu newspaper has also been divided into subsection based on the syllabus. And this daily news headlines is provided for every Hindu newspaper for every day and can be accessed from the Rouse IAS website. So if we take a look at the daily news headlines of today, that is 14th of December, what we have done is understood some of the articles in depth which have been given in the daily news headlines of today. And in addition to that, what we'll do is understand some of the small articles in a brief format for your UPSC examination. So now we start from page 1. And the first news for brief analysis would be taken from page 5, which is titled Scientists Step In to Save the Pungunar Cow. Now the reason the Pungunar cow is in the news is because this breed is on the verge of extinction. But what you need to understand from this article is first that the Pungunar cow is considered one of the smallest breed of cattle in the world. The second aspect that you need to remember is that the Pungunar cow traced their origin to Andhra Pradesh. And the last point that you need to remember from this article is that the Pungunar cow is on the verge of extinction due to the crossbreeding that has been conducted by farmers. Now what has happened is that various farmers in India have been importing foreign cows. And what the farmers are doing is crossbreeding between the foreign cow and the Pungunar cow. And what this has led to is the increase in the crossbreed cow, but a decline in the original Pungunar cow, since the farmers are now not breeding the Pungunar cows. and therefore because of this there has been a decline in their population. So now hopefully you've understood as to why the Pungunar cow is in the news and the 3 points that are required to be remembered from this article. Now moving on to page 6, the second article we'll be analyzing in brief is with regards to the migratory birds at Chilika Lake which are facing a flu threat. Now if you take a look at this map, the Chilika Lake is located in the state of Orissa. Now what you need to understand about the Chilika Lake is that it is the largest wintering ground for migratory birds in the Indian subcontinent. However, what has happened is that several birds such as crows and chickens were found dead because of the H5N1 avian flu, which is also known as the bird flu. And therefore this has raised a concern with regards to the lacks of migratory birds which have appeared in the Chilika Lake in the winter season, wherein there is a concern that these birds can also be infected by the H5N1 virus or the bird flu. And therefore the local administration has taken various measures such as killing the local chicken birds in the local poultry farms so that these migratory birds are not infected by the bird flu. Now with regards to this article, there are two aspects that you need to remember. First is the location of Chilika Lake. The second aspect that you need to remember is that it is the largest wintering ground for migratory birds in the Indian subcontinent. And the third fact that you also need to remember without going into depth is that the H5N1 virus is also known as the bird flu. Now moving on. Now coming on to page 7, we had already discussed the article with regards to groundwater extraction. And similarly, we've also analyzed the article in which the Supreme Court has said that there is a lack of basic rights for the aged. And so thereby moving onwards, from the editorial page on page 8, we have analyzed in depth the lead editorial. However, let us take a look at the article which has been given just below the lead editorial. Now as you already might be aware of, there was a recent killing by a mob in Bulandshahr in Uttar Pradesh of a police inspector. And what this article is highlighting are the various problems that are faced by the police officers which form the lower rank at the inspector and the sub-inspector level. Now you have to understand that this author has given an anecdotal references within this article, which means that the author has highlighted various personal experiences with regards to the problems that have been faced by junior police officers. Now the first problem that has been highlighted by the author is the lack of personnel, wherein the author has highlighted that the police personnel, especially at the lower level of inspector and sub-inspector level, who are expected to investigate crime, maintain law and order, currently lack in number across India. And this is because of two reasons. First, they have been deployed on VIP duty, due to which they are not able to fulfill their duties of investigating crime and maintaining law and order. And secondly, most of the positions of sub-inspector and the inspector level currently lie vacant by states. Now you have to understand that law and order is currently a state subject, and it is up to the state government to fill the various vacancies of inspector and sub-inspectors within their state. However, what is being seen in various parts of India is that the position of junior police officers currently lie vacant, and therefore because of these two reasons there have been a lack of personnel who are able to enforce law on the ground. The second reason given by the author is the lack of funds, wherein first, junior police officers are anyways paid a very less amount for the amount of work that they have put in. And secondly, because of the lack of funds, junior police officers also do not have the required equipments, wherein they are still using old rifles and guns, do not have proper access to vehicles, and therefore because of these reasons, they are not able to fulfill their duties of investigating crime and maintaining law and order. And the third and the last reason given by the author is the lack of motivation among junior police officers, wherein the first reason given by the author for the lack of motivation is the current working styles of police work in India, wherein what is required in the ground is very different as to what has been given as an order, and therefore this leads to a lack of motivation for junior police officers. When the author has given an example that police officers have been given a target to issue a particular number of challans, but what the higher authorities are not realizing is first that there are either few vehicles which are located in that area, due to which they are not able to fulfill the number of challans, and second, people simply do not have the money to pay the fine. And through this, the author is trying to highlight that this difference between the situation on the ground and the order from above is causing a lack of motivation for junior police officers. And the second reason given by the author is the deep-rooted corruption that exists in the system, So now hopefully you've understood the 3 points that have been highlighted by the author. Now you need to understand that as UPSC aspirants, you would already be aware of these 3 points. Now what you need to understand for your UPSC mains examination is about police reforms. And the topic of police reforms has been covered in depth and comprehensively by Mangal sir in the Daily News Simplified of 4th of July. And what I'll do is provide you the link to this video through which you can understand comprehensively about police reforms. Now let us move on. Now from page 9, we have already covered in depth the article with regards to the death penalty. And therefore moving onwards, now from page 10, the article which has been taken is India-Russia to boost joint production in defense. Now what has happened recently is that the 18th meeting of the India-Russia Intergovernmental Commission on Military Technical Cooperation was recently held. However, it is not required for you to understand either about this meeting or this technical cooperation group. Now what you need to remember from this article for India-Russia relationship is that the defense relationship between India and Russia is one of the few defense relationships that India has which has been elevated for joint production of defense equipment. Wherein what is currently happening that India's defense relationship with Israel, the United States, and with several other countries is based on an import-export relationship. Wherein what is currently happening is that India imports defense equipments from Israel, the United States, and several other countries. And what is India currently lacking is a joint production defense relationship with these countries. And Russia is one of the few countries in the world with whom we have elevated our defense relationship to joint production, wherein India and Russia have jointly produced the BrahMos missile and several other defense equipments. And therefore, with regards to this article, this is the only conceptual understanding that you need to understand from the perspective of GS Paper 2 within the section International Relations. And so thereby moving onwards. Now the next article that has been taken from this page is how do you appoint CIC officials as the Supreme Court. Now what has happened is that the Central Information Commission has huge vacancies with regards to Central Information Commissioner and Information Commissioners. And therefore the Supreme Court has asked the Government of India to disclose the process for appointment of the CIC and the Information Commissioner. Now you have to understand that this news is currently in transition, where you will have to wait and see on how the Government of India responds to the Supreme Court. However, what you need to understand from this article is the appointment procedure of CIC officials. Now the Central Information Commission was established under the RTI Act of 2005. And the Central Information Commission is to consist of one Chief Information Commissioner and 10 Information Commissioners. And they are to be appointed by the President of India based on the recommendations of a committee which consists of the Prime Minister as the chairperson, the leader of the opposition of the Lok Sabha, and a Union Cabinet Minister which has been nominated by the Prime Minister. And this is a fact that you need to remember, especially with regards to your upcoming prelims examination of 2019, that the Central Information Commissioner and the Information Commissioner are appointed by the President based on the recommendations of a committee consisting of the Prime Minister, who is the chairperson, the leader of the opposition of the Lok Sabha and not the Rajya Sabha, and a Union Cabinet who has been nominated by the Prime Minister. And with regards to your mains examination, the appointment of the Central Information Commissioner should be seen from the perspective of GS Paper 2 within the section Statutory Bodies. And therefore, with regards to this, you should also remember that the Central Information Commission is not a constitutional body since it has been established under the RTI Act of 2005 by the Government of India. And therefore, it is a statutory body which has been established by an Act of Parliament, which is the RTI Act of 2005. And so now moving forward, now from page 11, the news that has been taken is India ups ante over SAARC meets Spat. Now you have to understand that this is a political news of international relations, wherein what had happened is that the Minister of Pakistan occupied Kashmir was present in the meeting of the SAARC Chamber of Commerce and Industry. And because of the presence of the Minister from Pakistan occupied Kashmir, the Indian diplomat who was representing India in this meeting walked out. However, this is a small political news of international relations, and therefore it is not required to be understood from the UPSC examination point of view. And so moving forward, now from page 14, the news that has been taken is India-China join hands to promote tea globally, wherein what has happened is that two apex industry organizations within India and in China have signed an MOU to promote green and black tea consumption in major markets of Europe, US, Russia, and West Asia. Now, again, this is a small news with regards to international relations or with regards to economy. And the only fact that you can remember from this is that Indian and Chinese organizations are working together to promote tea in major European, US, Russian, and West Asian markets. And therefore, the last news in brief that we would be analyzing today is that apparel exporters want a hike in duty drawback rates. Now, what you need to understand from this is what is duty drawback rates. Now, duty drawback rates is applied to a certain amount of duties of the customs and the central excise, which are then remitted or paid back by the government on the exportation of those commodities on which they were levied. Now, in simple terms, if you take a look at the apparel exporters, so when a cotton ready-made garment is exported from India, the government pays back around 1.8 to 2.2% of the duty that has been levied on the export of cotton ready-made garments. However, what the apparel exporters want is a duty drawback rate of 4.32%, whereby the government should pay back around 4.32% of the amount of duties of customs and central excise for the export of cotton ready-made garments. So let's say to export a cotton garment, the exporter is paying 10% as custom duty. Now what the government of India would do is pay back 1.8% of this custom duty that the exporter has paid on exporting that commodity or the cotton garment. And this in simple terms means duty drawback rates. And therefore you need to understand the duty drawback rates from the perspective of your upcoming prelims examination of 2019. Wherein, if some of you remember, a question was asked in the 2018 prelims examination on the merchant discount rate, wherein the prelims examination had asked as to what is the merchant discount rate, and it is within that context that you should know as to what is duty drawback rates. And so now hopefully with this, we have completed a brief explanation of the various small articles that have appeared in the Hindu newspaper of today, which have also been taken in daily news headlines. And now with this, we come to an end in the analysis of today's newspaper. Now we move on to the question for today.